welcome to the firm. I've been waiting long for this episode because it tackles an issue close to my heart. On the show this week, an across-the-world view of eminent domain and public purpose. And where in the world would you find Lionel Richie, Justin Timberlake, Taylor Swift and Celine Dion all in one place at 7 in the morning? In a way, it's the modern-day version of the Battle of Kurukshetra. And in keeping with the times, it's being fought in Parliament between the government and the Parliamentary Standing Committee. Now, in 2011, Minister for Rural Development, Jairam Ramesh, drafted a land acquisition bill that proposes to allow the government to acquire land on behalf of private companies for public purpose. The bill defines public purpose as the building of roads, highways, strategic defense needs, etc. And that's all fine. But Jairam Ramesh's version of public purpose also includes projects by private companies, such as the setting up of a manufacturing plant. Well, last month, the Parliamentary Standing Committee disagreed. The committee's report defines public purpose to mean only state-sponsored projects, and that the government should not acquire land for private companies or even public-private partnerships. Well, it's not clear which side will prevail, but this face-off between economic development and private property rights has posed a challenge across jurisdictions. In this special story, Paiswini Upadhyay examines how eminent domain works across the world.
Eminent domain was first recognized in England 800 years ago. Since then, it has taken on a modern nomenclature. Land acquisition in India, compulsory purchase in the UK, expropriation in South Africa, resumption in Australia, notion of modalities in Mexico, and condemnation in the United States. In the US, the Constitution limits this condemnation power to say, "Nor shall private property be taken for public use without just compensation." Originally, public use meant just that, but its scope widened in the 1950s due to a US Supreme Court decision that expanded the definition of public use to include slum clearance. Currently, the definition of public use differs from state to state. In Michigan, the state Supreme Court laid down 3 parameters in 2004. Michigan allows for condemnation if it involves public necessity of the extreme sort otherwise impracticable, such as building of railroad and highways. Second is where the private entity remains accountable to the public in its use of the property, such as land acquired for a pipeline. And the third standard is where the selection of the land to be condemned is itself based on a public concern, such as elimination of a blight.
In the United States, each state, as I said, has its own fundamental common law with respect to what is allowable for a public use. In New York, for example, where I am based, it is almost without limitation that you can take someone's property and turn it over to a well-connected developer or something like that to build a shopping center. You can take someone's home and turn it over and build a Costco large mall shopping center. So New York is at the forefront of this, and it's also very difficult to stop a condemnation in New York.
Neighboring state Connecticut faces the same challenge. In 2005, in a landmark case, Suzette Kilo put public purpose to test when opposing the City of New London's redevelopment plan.
Ms. Kilo, what about the city's argument that you're standing in the way of something that would benefit the entire community, and it's sort of your interest versus the whole community?
We've never said that they couldn't put the development there. They have more than enough room to develop everything that they want to develop. We just simply wanted to keep our homes. There's over 90 acres, and we only take up 1.5 acres at best.
But the Supreme Court ruled otherwise and allowed the condemnation on grounds that economic development served public purpose. Consequent to the Kilo case ruling, 44 out of 50 states in the US changed their laws to better protect private property.
The most pointed argument with respect to eminent domain in the United States is taking private property to turn over to another property owner, a private owner. It's not a taking for a typical public use like a bridge, a library, a school, a highway. It's the taking of private property to turn over to a developer who's going to build a shopping mall or something like that. That is the issue that upsets most people.
It's this upset that led to the founding of civil liberties law firm, the Institute for Justice, in 1991. IJ prides itself for fighting the government against the use of eminent domain powers on behalf of individual property owners.
The expansion of eminent domain in the United States has been a disaster. We see eminent domain being used as a tool for those with political power to use against those with no political power. It disproportionately impacts minority and lower income communities. We've seen entire communities, thriving businesses destroyed for projects that ultimately are never built because there was no market for them in the first place. It's led to corruption and bribery, and it destroys any incentive for property owners to maintain their own properties with this cloud of condemnation over them, and drives away investment from communities.
Further south, in Mexico, the definition of public purpose can also be described as expansive. Article 27 of Mexico's constitution prevents expropriation except for public utility and on payment. Public utility has been broadly defined to include the creation of rights of way, municipal facilities and public services, as well as the creation or development of an enterprise that benefits the public, which could include private development projects. But there are safeguards. For instance, farmland or ejidos are entirely off-limit. Besides, Mexico's many free trade agreements and bilateral treaties also provide protection.
Well, Mexico has entered into several bilateral investment treaties and free trade agreements around the world, North America Free Trade Agreement being one of them, the European Union Free Trade Agreement being another, whereby Mexico affords foreigners certain protections in the exercise of eminent domain that go beyond the protections afforded under domestic law. And under the Equal Protection Clause of the Mexican Constitution, those protections would also be extended to domestic investors, and therefore the body of law in Mexico that protects against eminent domain is equally applicable to foreign and domestic investors.
Recent land battles indicate that it's less expropriation and more the fair compensation part that has been hotly contested in Mexico.
There's been certain applications of eminent domain that have been controversial only from a political perspective, but not from a legal perspective. And the most recent example would be when in the mid-2000s, early 2000s, I should say, President Fox was in the process of building a new airport for Mexico City and had selected some property nearby Mexico City. And in the process of exercising eminent domain for the acquisition of the land to build that airport, there were some political uprising by the landowners arguing that the compensation being offered to them was inadequate. And rather than it being ventilated through the courts, it became a political issue that was picked up by political parties and other political players in the country and became a political issue, but not so much a legal eminent domain related issue. For the most part, when eminent domain is exercised in Mexico, like I said, is for public works, and it's a smooth process.
While land may be much fought over everywhere, the battles are not quite the same. In the US, 60% of the land is privately owned, and eminent domain has most often been used to declare properties as blighted and transfer them to private redevelopers, all in the name of job creation and higher tax revenues. In Mexico, eminent domain laws are tailored to protect the farming population as well as attract foreign investment in land, a tough balance. In South Africa, eminent domain has been used to right a historical wrong.
In South Africa, land ownership is skewed along racial lines. According to one estimate, 87% of land is owned by whites and used mostly for commercial farming. 13% is owned by blacks, many of whom practice subsistence farming. South Africa's constitution allows for expropriation if the land is required for the purposes of land reform, that is, redistribution to restore equality. Alongside, the Restitution Act allows communities to claim for land as well.
The issues that have been grappled with vary. One of the major ones is that the government did set itself a target in 2008 to resolve as many land claims as possible. To date, very few of those have been resolved. Those that have been, the land that has been restored to communities before has found to have been not used, or at least not used optimally. It is for this reason that there is the green paper, which seeks to provide more infrastructural support to emerging farmers and also to farmers, to land claimants that have been awarded land in the context of land claims.
Leaving race and democracy behind, Singapore, at the other end of the globe, has used eminent domain to transform its economy. The 693 square kilometer island nation has had little else to bank on.
It has always been pinned on our land scarcity problem. And one other factor that is very important to note about Singapore is that other than our fantastic geographical position, we have absolutely no natural resources. We only have the human resource. And in order to spur on economic development, and I still want to reiterate the point about land optimization and rejuvenation of old or low-rise developments, the only way forward seems to be for the government to take the initiative. And it has not been customary for infrastructure development or public housing development or the development of industrial estates to be handed over to the private sector.
Singapore's Land Acquisition Act allows the minister to notify an acquisition if it's for a public purpose in his opinion. The act does not define what constitutes public interest or public utility. And experts say most objections in this regard have not passed muster in the courts.
Initially, when we were part of the Strait Settlements, we have been using the Land Acquisition Act borrowed from the Indian Land Acquisition Act. Subsequently, when we became part of Malaysia, the Federation of Malaysia, Singapore was part of Malaysia at the time, and it's interesting to note that there were provisions within the Constitution which provided for adequate compensation. Now, what I must highlight here is that upon gaining full independence in 1965, this particular provision about adequate compensation is no longer there. And one of the most dire criticisms about Singapore's land acquisition provisions is that compensation used to be backdated to a retrospective date. In other words, if a piece of land was being acquired, it was not the current market value that was being paid as compensation. Rather, it was pegged at a retrospective statutory date. Now, all this changed in 2007, February 2007, when the law was amended. So as things stand today, at present, post-2007, current market value is given as compensation. But having said that, it's also important to point out that most of the development had taken place during the years when the compensation was pegged at a retrospective date.
Since then, the Singapore government has upped the compensation to aggrieved landowners by providing them with housing subsidies, ex gratia payments, relocation expenses, legal expenses, and priority in the housing queue for public housing. In democracies, even that may not be enough. For instance, the big land battles in India, Nano Shingur, POSCO, Orissa, were less about compensation and more about forcible acquisition. For centuries, in countries across the world, it's been one of the most difficult questions to answer. Should the government be allowed to forcibly take away your land?
I found it easier to answer that question by personalizing it. Would I be okay being forced out of my home? Absolutely not. Maybe yes for a nation-critical dam or highway that cannot be built anywhere else, but absolutely not if someone wants to set up, let's say, a cold-rolled steel plant in my backyard. That too on their terms? Well, no way. Let's take a quick break. On the other side, we kick off AGM season with a Celine Dion concert. Yes, you guessed it right. We're going all the way to Arkansas.